It is the sheer popularity of our distinguished speakers today that we've reached the maximum attendee limit, and our apologies to those who could not log in for this session. In the new normal, webinars have become an interactive and useful tool by which we can gain invaluable insights from the very best legal minds. Having said that, I'm sure you will agree that we have been privileged to have an absolute stellar panel of speakers with us today, who have been kind enough to spare their invaluable time and impart their wealth of immense knowledge and experience. We are immensely grateful to the honorable speakers for being with us today. Our speakers do not need any introduction to anyone practicing law or otherwise following the developments of Indian law. I will still attempt to do so. Honorable Mr. Justice Sanjay Kishan Kaul was a seasoned litigator and a designated senior counsel, having a varied area of practice pan-India before his lordship's elevation as a judge of the Honorable Delhi High Court. Since his elevation, his lordship's first as a judge of the Delhi High Court, then as the Chief Justice of the Punjab Haryana High Court and the Madras High Court, has authored several landmark judgments, many of which are in the field of arbitration law. That upon his elevation to the Supreme Court, his lordships has continued to author seminal judgments and lend clarity on several areas of law. We could not have a better speaker. Thanks, sir. Thank you for being with us today. Our other speaker, Honorable Mr. Justice Rajiv Shakdhar, also has a distinguished practice as a litigator and was a designated senior advocate before gracing the bench of the Delhi High Court. That upon his elevation, his lordship has held the arbitration roster several times and has authored landmark judgments on various issues related to the Arbitration and Conciliation Act and other laws. We once again express our immense gratitude to our honorable speakers for being a part of today's webinar. Before I hand over to my co-moderator for today, Mr. Shashank Garg, partner Advani and Company and a seasoned arbitration practitioner himself, I would like to convey certain housekeeping rules that will enable us to get the most out of today's session. The audience will be in a listen-only mode to avoid any ambient noise and bandwidth issues that we may face. In case you have questions, there is a question tab on the right-hand side control panel of your screen. Please feel free to put in your questions during the seminar or at any time, and we'll take those questions at the end. Just to make this session a little more interactive, we've put in a couple of poll questions, and we'll introduce those poll questions and request you to click on the answers, and we'll have the results shown simultaneously. Over to you, Shashank.
Thank you, Aseem, for the detailed introduction and those housekeeping rules. Just to add to what Aseem has already stated, on the suggestion of our distinguished panelists, we will attempt to make this discussion very interactive. Not only poll questions, but also the questions that we'll keep receiving from you will be discussed by this distinguished panel. Therefore, I would request, while putting your question, please make sure what is being discussed and keep your questions not limited to a broader subject and not ask a question on an ongoing litigation. That would not be proper, and I'm sure the judges would not be comfortable answering. So keep that in mind while these questions are being discussed. Before I request Justice Kaul to give his preliminary remarks, may I request at the back end to put the first poll question on the screen for everyone to answer, please. You're all requested to answer this question. Okay. So the results have also come in, and 40% of the people say in the present ecosystem, ad hoc arbitration is what they would prefer, and 60% of viewers say that institutional arbitration is the preferred mode of conducting arbitration in the present scenario. This is only one of the aspects of the discussion that we would be covering today. So I would request Honorable Justice Kaul to give his preliminary remarks on the subject that we are discussing. Over to you, sir.
Thank you to the panelists and the people who have organized this program, and to the audience. Provides discussion on law, an interactive one in times of lockdown. I think that itself is a great opportunity. And I also have the benefit of sitting with my colleague, Justice Rajiv Shakdhar, with whom I have shared a bench for a year and a half in the division bench. Well, coming to the subject which is at hand, I would say largely there are two aspects of it which will arise. The first one is the issue of party autonomy vis-a-vis the concept of independent arbitrators being appointed. That has really arisen out of some recent judgments of the Supreme Court. And I think there are some, if I may say so, conflicting signals emanating and creases arising which may, over a period of time, need ironing out. One view which has now prevailed and which has arisen from the judgments in TRF and Perkins somehow seems to go against the concept of party autonomy so far as appointment of an arbitrator by one party is concerned. So it seeks to give a go-by to this concept because a party would already be an interested one in the litigation, whether it's the managing director of a company or any of these scenarios. The observations have been to the effect that they may impede the independence of the arbitrator. But how does that gel with the concept of the party autonomy is a question which arises. On reading of the provisions of the Act as they stand, as also with the Law Commission reports, there has been a lot of emphasis on party autonomy. So where does the party autonomy stand? People enter into contracts. They may be building contracts. They may be contracts relating to supply of goods, or there may be contracts really arising with government or public bodies. Now, the perception is that in the government appointments, they tend to appoint people who may have a vested interest or may be part of the organization, even if they may not meet may not foul of the 7th schedule and the 5th schedule. I have a little reservation on this issue that while some countries accept a single arbitrator appointed by a party, others may not. The question is this a function of the legislature? Should the legislature have a rethink? That's one aspect of the matter. But if the legislature, in its wisdom, and the Law Commission, at whose recommendation this is done, seems to support party autonomy, then whether this party autonomy arising from a contract can be given a go-by is, I think, a point which will arise for discussion and further debate in judicial pronouncements. The problem faced with even government institutions is that my own experience is that it's not as if the people appointed by the government in these cases have really overtly favored the government. In fact, the problem, I think, is the other way around, where the government is seeking to challenge practically all the awards. And I used to sometimes wonder, sitting on the original side of the Delhi High Court, as to when is to ask the question also to them, that you possibly keep appointing the same arbitrator again and again and seem to be dissatisfied with the arbitrator. It was a mix of, I think, the way litigation is followed from the government side before an arbitrator, not giving the full material at times deliberately so, and on the other hand, the ability of the private parties to have a better overreach to the arbitrator for not using any other methodology for the time being. So I don't know really how bad is this concept of a party appointing an arbitrator. I also feel the whole purpose of including a 7th schedule and 5th schedule is to, one case, the red list, to disqualify anybody. So that's the arbitrator would not be a person eligible to act as arbitrator. And then there is the 5th schedule, which is a list of the lesser do's and don'ts. By these two, the legislature seems to take care of the situation or the problem which was supposed to have invested in the Indian arbitration system. Therefore, either a legislature or a law commission should have a relocated. Otherwise, it does to some amount, may amount to a judicial legislation in terms of introducing something which the legislature has not. There is also an aspect arising from the judgment subsequently in the rising in this railways matter. The Center for Railway electrification, where a distinction is sought to be carved between a panel of arbitrators suggested by the appointing authority and nomination of a arbitrator. Now, the manner of railway arbitration, which I have some experience of dealing as a judge, is only that they create a panel of their ex-employees, out of which they normally would ask you to give an option to pick up 1 out of 2 or 1 out of 3. And the remaining 2 arbitrators are appointed by the authorities themselves. So in any case, if the principle of party autonomy has to be whittled down, then I am finding it a little difficult to reconcile a situation where 2 arbitrators would be appointed by the authorities and 1 appointed by the private party out of the options given to them. The concern which is also rising is that if you give a total go-by to party autonomy, we will face with the situation, more so as it is seeks to operate judgment retrospectively, that what happens to arbitrations already in existence and arbitrators already appointed. There will be a huge deluge of objections under Section 34 in this area, because at the relevant stage, this issue had not arisen. So I feel some discussions and judicial debate in courts will have to occur to possibly around a practical approach whereby you keep the principle of party autonomy in mind and yet set down the principle which will not compromise the arbitration in terms of its integrity. The second aspect, which I'm sure is going to be debated, on which there was a question posed, was the institutional arbitration versus the ad hoc arbitration. At this stage, I will only say that one of the linked debate is whether the ad hoc arbitration can take place with the court asking the institution to appoint an arbitrator. That is not being governed by the rules of the center, but only the appointment process being done. Now, my own experience is that when both the sides are represented before the court, it normally suits the court and the lawyers both to have an agreed arbitrator before the court rather than leave it to the institution. So unless this culture catches on, and I don't know really when will it catch on, there may not be too many cases of this nature where the matter would be referred to arbitration. Arbitrator to be appointed by the institution. My own experience of this is because I've sat on the original side of the High Court. Normally the Chief Justice used to appoint, so in Punjab, Haryana and Chennai both for almost now 4 years when I was Chief Justice, these cases used to come before us. And often even where the requirement was for appointment of a 3 arbitrator panel, they would accept a single arbitrator to save costs if the court was appointing an arbitrator. The other aspect I would say out of this experience is that the problem really arises in terms of the cost of arbitration in terms of the fee of the arbitrator. Now, that is in case of an institutional arbitration more so, because sometimes arbitrators are not willing to operate at the fee levels of the institutional arbitration. But this is, I feel, is a more Delhi, Mumbai, and Supreme Court judges centric problem rather than elsewhere, because I didn't find either in Chandigarh or Chennai any of the arbitrators having any reservation to work on that basis. And personally speaking, I feel I am in favor of appointing judges, lawyers, sometimes family members and family disputes, or even technical people to arbitration, and including upcoming young middle-level lawyers who sometimes are there to perform. I at least used to appoint them in smaller stake matters because it would not be worth the while sometimes of a retired judge to handle them. And all these varied experiences have worked well. The only principle I think to be followed while appointing an arbitrator is the same principle in some sense which operates while appointing a judge. Because I've observed a number of times that an arbitrator is an agreed judge, the nominated judge. So principles of integrity, principles of ability to understand and quickly dispose of the matter and control the arbitration would remain the objective even while appointing these arbitrators. I think that more or less would cover the broad contours of the subject. In the next, we will debate from what Brother Shabda says or what follows from Shashank, Kasim, and the people who are attending the session. Thank you.
Yeah. Thank you, Justice Call. You've broadly sketched the contours of the difficulties that we face while dealing with petitions under Section 11. But before I delve into it, let me just share a experience that I encountered as a lawyer, which I have taken to the bench. Long years ago, seems almost centuries, but it's only a couple of decades. When I was a lawyer, I happened to carry a matter to the Supreme Court against a judgment delivered by the Delhi High Court. And lo and behold, I was faced with one of the best commercial minds on the bench, who also traveled from the Delhi High Court and went on to become the Chief Justice of the Supreme Court. And I think Justice Paul would fairly guess the name. I'll tell him at the end of it. And the first thing that he told me was, young man, arbitrate and don't litigate, by which he meant don't litigate in court. This is something that I have carried with me to the bench, because we are two sets of people, both on the bench and the bar. There are one set who think every remedy lies in court, and therefore, everything needs fixing in court. There is another set who think that once you've made your bed, sleep on it, and therefore you've chosen a route of a private judge, so to say, stick to it. So the thumb rule that I broadly follow, and I think most of us who fall in that category, is don't try and fix something which is not broke. As I said, sleep on the bed that you made. And therefore, the other broader principle that doesn't involve Section 11 is that when ultimately an award comes and we try and fix it by a public policy route, generally, that it is really an unruly horse. So having said so, I have found, and Justice Call, this is something that when I experience, there is a certain amount of, let's say, concern, which is this, that at the threshold, we get stuck in Section 11 on issues of territorial, whether the party concerned has approached the correct court, high court, whether the party who has triggered the Section 11 petition is the party which can. And interestingly, in certain cases, and one case did come before me, which I'm going to share, is whether the dispute is relatable to the agreement. And of course, the other dispute which was pending and the Supreme Court seems to have perhaps now taken a view is the arbitration agreement is, if it is not stamped sufficiently, then it can't even trigger your jurisdiction. It's my concern, are these not issues which can be ironed out by the legislature? I must say, in fairness, the legislature or the executive via the legislature, with the amendments which were brought in 2015, tried to fix it by bringing in subsection 6A, capital A, where they said that all that the court has to look at is whether or not an arbitration agreement is in existence. And they went on to say, the section broadly says that notwithstanding any judgment of the high courts, Supreme Court, decree, etc., this is the only aspect that you are required to see. The judgment of the Supreme Court in Duro went along, but then there was another judgment which sort of upended the whole thing and said, no, it's a judicial exercise, you need to look at it more closely, and there are other aspects that you are required to look at. Fortunately, the Supreme Court has again, in the Northern Coalfields case, I think Justice Indu Malhotra led that bench, has again taken a view consistent with Duro. Now, what lawyers generally face, therefore, is perhaps, depending on, let's say, the bench you have before, what is it that is going to appeal to the court in terms of already laid down law, is how they try and negotiate these problems. So, apart from this aspect Justice Cole raised about the autonomy versus what the court tries to do to get over this problem of not allowing for I may say arbitrators who are appointed by one or the other party without the other party being given the right. These are issues that need to be dealt with. Now, Supreme Court, even prior to the amendment, tried to deal with this issue in Raja Transport, where they applied the principle of impartiality and neutrality and got out of a contract which gave only one party the right to appoint an arbitrator. So party autonomy was actually put on the back burner. DMRC again followed that. While they recognized the principle of, Supreme Court recognized the principle of impartiality and neutrality, ultimately allowed DMRC to appoint an arbitrator by broad-basing its panel, by including people who are not necessarily connected with the organization. So what Justice Cole was saying, to only add to that, if at all you need to balance this, I think the legislature also needs to make up its mind which way it wants to go, and therefore, since a large majority of litigation is by the government, they can make up their mind. Otherwise, as I see it, the balance can be arrived at by following the DMRC route, which is broad-base your panel, and have senior advocates, lawyers of integrity, domain experts, retired judges on your panel, including engineers, etc., who've dealt with not the organization or the public sector involved, but other organizations. So these are my brief opening remarks on the.
I'll just add one more thing to what Rajiv said. See, I agree with you. Don't try to fix something which is otherwise not a problem. But the law with arbitration has been that the problems have emanated largely from our side. So every time the legislature has tried to fix the problem, we have tried to fix it some other way. This is the hard reality. So therefore, yeah, we have tried to interpret it in our own way, certain things, which is not with the intent of the Law Commission, which makes recommendations, or the enactments. So either the legislature decides what it wants to do, as you are saying. Question is, should the court hold its hand and go by as the act stands, or should it evolve its own processes in this whole thing?
Which is why, Justice Cole, I said that the legislature didn't do its bit by introducing 6A. I thought that was clear enough. They couldn't have made it 6A to subsection 6A to section 11. They couldn't have written in more clearer words, but even so, we had judgments which did take contrary views. So there was this.
There's been this debate. I mean, in Madras, I faced it. I took a particular view. Like I said, if an employee has retired, say 6 years ago, has not worked with the contract, then one will have to see Schedule 5 and the Clause 31, which is dealt with it. And therefore, we can't import that into the 7th schedule. Otherwise, the court would, the legislature would have said no employee who has ever worked with the organization should ever be appointed. So the legislature left a little leeway and did not want to completely bar certain things, but the recent pronouncements seem to bar the very things. That's the challenge which is arising.
Yeah, so therefore, I think, once you amend the law, the government, to cut down the litigation, has to somehow, because it's the biggest litigator in court, has to somehow send the message that wherever you can, irrespective of whether the contract is arrived at before or after, you must agree to fall in line with what we have intended by way of an amendment. Because what is happening is, if you see the Supreme Court judgment which has taken the contrary view, one of the ways they have sort of negotiated, subsection 6A of section 11 is by saying these were contracts which were executed prior to the amendment, which is 23rd October 2015, or the process was triggered much earlier. So the judgment in the Central Organization Railway case, if my memory serves me well, is taking into account those factors. Therefore, there has to be a conscious attempt at aligning with your legislative intent, because if that doesn't happen, there is always that chasm which then the courts are necessarily bound to fill in, and we therefore land up with judgments which sometimes are not consistent. That's how.
So just taking this first issue forward of unilateral appointment of the sole arbitrator, I think the real difficulty lies with the limited scope of section 34, and therefore the choice of arbitrator at the stage of 11 becomes very critical, because you do not want an award which obviously in 34 the scope remains so narrow, and a bad award you may not be able to get it set aside just on the acquisition of bias, etc., which may be apparent because of the way the arbitrator was appointed. The larger question is with respect to agreements of NBFCs and developer allottees, and not really the government contracts, as Justice Kaul rightly pointed out. I think there is a bigger nexus when we look at the contracts of non-banking financial corporations with the people who are seeking loan, and as well as developers with the allottees, where there is absolutely no equal bargaining power, and also the arbitration clause would put a seat somewhere in the remote corner of the country. By the time an allottee will realize that there is an arbitration that is being conducted, there will be an ex parte award, and 120 days time period would have already elapsed. So therefore, I think Perkins may be an extreme approach, but certain discipline may be required. I mean, that's my thoughts, sir. I thought I'll just add to what Justice Shabdar has said.
No, if this question is towards me, Shashank, I am completely, aligned to your view in a sense that I can tell you that you are right, where there are a lot of these NBFCs or finance companies who have, should we say, stock arbitrators. They're not even judges. They are lawyers who actually act and plead for them. They are also appointed as arbitrators. And you are also right that the company may be, say, operating in the state of Tamil Nadu, and the person who has taken loan against whom they wish to proceed maybe in, say, the state of Gujarat. So he doesn't even have notice, arbitration gets triggered, award comes, and it comes for execution. That's when the gentleman gets to know. So you are right. Now, these are difficulties which are known. So when they were, my short point is, when this was being amended, whether it is an NBFC or a government entity, which has a contract prior to the amendment. So when you put in 6A, you could have also said that made necessary amendments as to, the person who has to be appointed as an arbitrator. I mean, this court has stepped in, whether it is prior to 2015 or after, where the court has said, you need to apply the same principle that you would apply to a judge, which is he should be impartial and neutral. Taking that principle forward, they have negotiated, but not always. See, when you have a big public sector as railways, courts feel that sometimes they feel, as long as you have a broad panel, what difference does it make? But parties are not happy, and the private party could also be a big concern. You could have an LN, I mean, I'm not naming companies, but you could have a multinational at the other end. So they enter into a contract knowing fully well they're not actually, persons who are without wherewithal. And then the government comes to court and says, listen, when they entered into a contract, they got the benefits of the contract, they were quite all right. When it came to litigation, they suddenly find that the arbitral mechanism is not neutral. So, like I gave you the DMRC case, what did the Supreme Court ultimately do? It didn't say that the party autonomy is done away with. It only broad-based the panel. That's the hard reality.
That's
I don't know. Justice Cole may have a view as to what he wants to say on this.
No, I said in the beginning, see, as you said, you elect a judge, you choose a judge. And therefore, there should be faith, not in during arbitration. Sometimes people draw perceptions, not that way, but at the inception, it is very important. Then one of the crucial problems, apart from others expanding the scope of scrutiny of awards, has been this, that at times the judges have also felt that if the arbitration award does not smell right. Sometimes you get that sixth sense over a period of time when you work with it. And there are often cases where largely it is not appointment made by single parties, and as I said, not necessarily the award favoring by the party who's nominated them, but even otherwise. So I don't know how far I would go that the nomination power is the problem. Issue I have is the nomination often occurs in a large number of cases by the government, and the government is the one which is worse off for it in the markets. This is my understanding of as I've seen how it rolls on while scrutinizing the objections to the award.
So just to take this debate further, can I just ask for the second poll that we have? It's on unilateral appointment. Let's see how the audiences feel about unilateral appointment vis-a-vis appointment by court. Can we have the next poll, please?
I think there's a typographical error. The first answer should be such an appointment is now impermissible and not impressible.
Yeah, impermissible it should be. I think lawyers will understand that.
We have a very close
Tie, actually.
yes, close response. I mean, it's almost a tie, 55-45.
Can we have the answers now, please? Can we show the poll? Now, sir, the poll is actually quite narrow. It's 55:45.
Yeah, because if you compound the problem a little more, because the jurisprudence, the principle of law or the jurisprudential principle can't be different depending on, what is the status of the party or the station of the party in the society, or whether it's an individual or a company, etc., etc. Now, suppose you have two MNCs, and in the contract, the MNC has given the power to the other to choose the arbitrator. Now, after the disputes emerge, the other side comes to court and says, listen, I have no faith in this party, and I'm not going to permit appointment of arbitrator by that other company. You can think of two major companies in India, any two major companies. Would we apply the test of impartiality and neutrality and say yes? And if we have to apply that, is it not very simple for and I agree, if that should be the test, because ultimately you are adjudicating whether you are an arbitrator or a court. Should the legislature not make it clear and say, no, arbitrators will be, neutral and impartial persons and can't be aligned to one or the other party? That's all. Because otherwise you will have this quagmire and cases going one way or the other, and the courts will try and see in each fact situation how it emerges. So,
but which is the right opportunity, according to you, where such an objection should be raised? What we are seeing now is that Perkins is being applied retrospectively, and like Justice Call pointed out, that a party goes through the rigmarole of the arbitration, and eventually at the stage of 34 says that the arbitration itself was non-est in view of the law laid down in Perkins. So do you think that the issue of unilateral appointment, which is upheld by Perkins, that it cannot be done anymore, is open to misuse by parties?
Yeah, I believe so, especially for pending arbitrations, because on an aspect like this, arbitration which have already arisen, either they'll get stalled in the middle. My apprehension is they may get stalled in the middle, or you may face the music at the end of it. So the whole purpose is has been so far, don't stall the arbitration in the beginning. But equally, what has been thought about is that the section 34 should not become another appeal in a suit. And you must learn to, the concerned judge, which Rajiv was referring to, would say this similarly, that when he says you learn to accept awards. So there were people who used to say, look, it's for example, there used to be, of course, not under this act now, or non-speaking awards. So it was given a label of a snake bite. There is no cure for it. So now, of course, we have reasoning, but then people expand saying how much should be the reasoning. See, the whole point is how many tiers of scrutiny should everything have. I have this perception even in court, that even a normal litigation, how many tiers of scrutiny should be there? If you create a court above us, I'm sure half of Supreme Court orders would also face some interventions. So that's the problem. Now, when you choose an arbitration forum, the idea is you elect a judge and you by and large accept whatever he says. Ultimately, you accept somebody's decision. It may be the Supreme Court, it may be the High Court. Somebody's decision is final. Here you say, look, I don't want to traverse through these various tiers. So look, I have somebody whose award is a process of adjudication I will accept, except for really exceptions. And I think that purpose gets defeated if there is a repeated interventions.
According to me, Shashank, you want to say something? So please come in.
After, I was just moving forward.
Please, then because I wanted to say something apropos to what Asim said. So Asim, you raised a very important issue. Whether people will now take advantage of Perkins. I can cite a live case where at section 34 stage, the live case in the sense it's already concluded, but it went through the High Court and it's reached the Supreme Court. The Supreme Court has also given a decision. So not live as in alive before any court at the moment. After the award was delivered, a government entity said this award needs to be set aside because even though I appointed the arbitrator, the appointment is not aligned to the amended act. I think it's Bharat Broadband. The Supreme Court accepted this. The award was set aside. Now, one view could be, listen, what were you doing when the appointment was made, when the arbitration was going on? You didn't say so. But now that the award has, come by and it is against you. So these are the difficulties that we are facing. Like I started by saying that why is it at section 11? And I have told our friends at the bar several times, even if the person is in the wrong court, both of you are represented. The only thing that you are achieving, if I agree with you on the territorial objection, is you go to another high court. But arbitrator is going to be appointed because you have no other objection. Why don't you agree to an arbitrator being appointed by this court? I mean, you save money, you save time, but you find in several cases people just don't agree. Now, this is an area which is, to my mind, aching to be rectified by the legislature, irrespective of where you file. Once it is not a case of, deprivation of substantial rights, that means party cannot approach the court and defend, etc., the petition. Once the party is represented, then why on the basis of merely not being in the right high court should the process come to a halt and get delayed? Because ultimately an arbitrator is going to be appointed, and I'm proceeding on the assumption that there is nothing else wrong. Like we do it in FIRs, Supreme Court has clarified that if you file it in the wrong court, it can it is treated as a zero FIR and it gets transferred somewhere else. But we could move a little ahead and say the legislature could say that this is not an objection which is sustainable. Otherwise, this process doesn't start.
My impression is that sometimes where the objections would be filed arise becomes a aspect which concerns the party. So I've dealt with a situation where I could by consent persuade the parties, look, let us appoint the arbitrator. And the party will agree that were the challenges to be raised for all jurisdiction purposes, the other court may have it. But you agree, then it's an agreement of the parties by which you are only recording. So that seems to be the reason why.
No, Justice Call, you're right. That's exactly what we do. But these are not things that can't be rectified in the Act. That this will not take away your right to object at this 34th stage as to whether this is the right court or not. You know, I'm just thinking, otherwise you get just stuck at the threshold.
I agree, but the point is that if there is a designation and you know which court you have to go to, why should you come to another court? It's the same way. It's like saying that any court in a civil suit also will ultimately try the civil suit, but there is a jurisdiction defined. So sometimes party do it for reasons which are not the best of reasons why they approach a court. There may be cases where there may be genuinely some misunderstanding. So I don't know really which kind of case would a particular case fall under. But yes, we take inordinately long time in appointing and inordinately long time in deciding the award. So I can say from Chennai, when I started sitting on arbitrations, there were, I think, more than 500 cases of appointment. And the oldest case I dealt with, in a live case in the sense the appointment did take place, was 1999. This is sometime in the year 2016, possibly 15 or 16. This is unacceptable. Please understand. So a live arbitration in so much time, a suit or an appeal should also be decided. So some concentration has to be done to see that these two stuck-up areas are not done. And Section 11 itself has been, I'm sure the position will be same with different courts where there may be large number of older matters pending in some way to get rid of them.
So another issue which stalls the Section 11 application as a very crucial issue is the scope of scrutiny at the pre-reference stage itself. And we have seen back and forth right from Patel Engineering to 2015 amendment and then the 2019 amendment, although not notified. But if Section 6A is to be taken away, and if we look at the scheme of the Act as 2019 amendment suggests, what it says is that after Arbitration Council of India comes in place and there are designated institutions under the jurisdiction of a particular High Court or the Supreme Court, the Supreme Court and High Court will have to mandatorily ask that institution to appoint the arbitrator. Therefore, the power to appoint will be mandatorily transferred to a designated institution. However, 6A is being taken out. Therefore, the scope of interference is still there, not interference, but scrutiny is still there. So this has rather led to a two-tier process instead of making it swifter. What now my perception is, subject to what the learned panelists think, that a person would have to file a Section 11. The court will first determine the preliminary questions, whether to looking at the existence of the agreement and ancillary questions surrounding it, and then send it to an institution for appointment. So post notification of these amendments in Section 11, this would rather, I think, become a more cumbersome process than what was intended. I mean, my request is for the panelists to reflect upon what should be the scope of interference or scrutiny at the pre-reference stage by the court.
See, I feel the scrutiny should be limited, but I don't know whether this will serve the purpose of having some kind of one forum and then another appointment process. On top of that, the issue is, you see, somewhere what has to be balanced is, if everything is postponed to Section 34 stage, then when you go through the whole thing, having gone through the whole thing, you come to a stage where you nullify everything. That is the basis on which Section 11 scrutiny got expanded. But then expanded so much that it became another battle at Section 11 stage. Now, I would find it difficult to lay down a hard and fast rule, but some way you have to leave it to within the scope to the judge's discussion that given the position in Section 11 should not be an impediment to commencement of arbitration, yet Section 11 should not be done in such a superficial way that it becomes an expanded battle under Section 30.
Yeah, I would agree with what Justice Kaul just said. I think the attempt has been, and somewhere perhaps there has been this dichotomy, but the object appears to be to move towards an institutional arbitration, and which is why I think your poll has also suggested that the majority of the people want institutional arbitration, because once you have institutional arbitration, these doubts that you have about the arbitral tribunal to a very large extent get reduced. Grading is a good aspect. I think Shashank would remember, I don't know whether he was then the member of the arbitration committee that the Delhi High Court Arbitration Center had, where I had suggested even before this came that, when you have arbitrators on your panel, it is a good idea to have some kind of grading, an anonymous procedure where the person who grades the arbitrator doesn't know who he is grading on some objective parameter, because any institution, for it to offer first class services, at the core needs to offer a panel with domain expertise, panel of arbitrators who are known for their efficiency and integrity, impeccable integrity. And therefore, if you were to do something like that, it would enhance the stature of the institution and take away more of all these problems that we face about the appointment procedure, the person who's being appointed, etc., etc. So the thought is good, but yes, you're right. There are certain aspects which may have to be ironed by courts, on which perhaps at this juncture may not be feasible nor proper for us to comment. That is something that we will, if it comes, one deals with and other judges will deal with. But the general thought of grading is not bad. People have views about the way it has been vested in a particular council, the construct of the council, the members who are going to be appointed, etc., etc. If that can be looked at by the legislature, maybe most of your concerns will get taken away. But speaking for myself, I am for grading of institutions so that they offer the best services.
So just taking a case from that. Sorry, go ahead, sir.
Something that I thought, Shashank, you would remember, but I mean, as lawyers, the members who were on my committee, were shy of doing this because they have to appear before arbitrators.
Our perception is that arbitrators may not be very receptive to this suggestion of putting them to some sort of a feedback process. But I thought that it was a great idea. In fact, even the top moot courts around the world, like Vienna Moot, where arbitrators go and arbitrate, the teams that participate give a feedback so that the organizers can reflect upon it and invite those arbitrators who got a decent feedback to the next edition. So.
See, Shashank, my short answer is, Justice Kaul perhaps may agree, that we are called upon to take very tough decisions as judges. Sometimes I find that when you are told to take that decision, you fellows will say, okay, we'll not take that call. But I think that these tough calls as an arbitration bar you need to take. It's going to subserve the system.
From a lawyer's point of view, in fact, Shashank and I, a lot of us always deliberate that sitting as a judge exercising powers under Section 11, what weighs in the mind of a judge while appointing an arbitrator? There are no guidelines. What factors guide judges that you are not getting into the controversy, you're not getting into the merits? How do you end up selecting or appointing the judge, that or a retired judge or a technical member, or who? How do you come to that conclusion that who's the right arbitrator to be appointed in a matter?
I think Justice Kaul would answer this.
I said the same principle I would say if I was to make a recommendation for a judge. Integrity, understanding of law, ability to finish quickly. Broadly, the same principle would apply in a different sense, but of course, I think integrity is a very important part of it, and a quick adjudication is also very important, because That's why people are going into arbitration rather than the courts. So one of the major reasons that is.
Justice Paul, you would agree. First two are, yeah.
No, I said after this, if you open the question to the audience, we'll run out of time otherwise.
Yeah, just to add this, while you're saying integrity and efficiency are the prerequisites, I think time has come to also look at domain experts. Even judges, sometimes when in their career as judges and lawyers, would have done certain areas, would have dealt with certain areas more closely as against others. So, looking at the complexity of the disputes, it's also necessary to look at some amount of domain expertise while appointing an arbitrator, right?
I would agree, but when I say ability to quickly decide, some way your domain expertise is an important part. If you pick up somebody who's you pick up a judge who's never done commercial law, I think there will be problems.
Yeah, you can. I think we can open it if you want.
So would you take up the audience questions, the ones that we had received? And one is a follow-up question on the scope of scrutiny with respect to non-signatory. Would you want to start with that?
Yeah, so we've just seen a lot of questions. In fact, time permitting, we'll try and cover as much as possible. The first question which has come in is from Mr. Divekant Lahoti, who says that if there are signatory and non-signatories to a Section 11 petition, can a signatory and non-signatory file a joint petition against the other signatory and invoke powers under Section 11 of the Act?
See, this has been a debate whether the signatory certainly can invoke. Question is, can you rope in the non-signatory without his consent? If his consent is there, my own view would be the arbitration principle of an ADR is wide enough, and the other side should not be logically be able to object to it that somebody else is coming into the arbitration. If the subject is such that his presence would help in adjudication and he is willing to come in, because there cannot be an involuntary arbitration.
Correct. So therefore, there would be two facets. One would be non-signatories who are willing to join an arbitration, and therefore court will examine that aspect differently than a non-signatory being forced to made a party in an arbitration.
I would say the two things will have to be looked at a little differently.
Right. So we have also received a question on mandatory arbitration under some enactments. So I'll take up the example of MSME Act, because I see from the question window there are a few questions on MSME Act. So MSME Act provides for mandatory arbitration if there is an involvement of a micro, small or medium enterprise, even if the agreement doesn't say so. What would happen if the agreement also provides for an arbitration clause, and there is of course a mandatory arbitration under the MSME Act, and a party chooses to go, the party being not the MSME but the other party chooses to go in under the regular arbitration clause, and MSME actually subject to the jurisdiction of that tribunal, and later on realizes that it had better powers or better privileges under MSME Act, because the MSME Act provides for a compound interest, and then want to withdraw its consent and switch to a MSME Act arbitration. Would that be permissible, or once they have chosen to go before an arbitral tribunal, they will have to stick to that?
I'll let Rajiv take it, because I have some impression that something like this is coming forward. So I will let Rajiv take it.
Yeah, okay. See, Shashank, it's also in the realm of something that perhaps one would like to answer, but let me just give you a broad answer to this. The broad answer would be that if you have again chosen to go by the agreement that has been arrived at between parties, can you midstream change course? Depending on fact situation, how it evolves before you, I think there is a very narrow scope, but I won't give you a definitive answer, because unless I see the scheme of the act, the scope of the agreement, this is a question which is best left to be dealt with in a live case rather than on a very theoretical sort of basis.
You take the next question, Asim, from the audience.
So Mr. Amar Sundaram has a interesting question actually. He says that in view of the COVID-19 situation, do you think time-bound mediation should not be made compulsory in commercial disputes by way of an amendment to the Arbitration and Conciliation Act so as to reduce pendency of arbitration cases?
See, it depends on the clause here. My own view, I am a person extremely partial to mediation process. So I don't know. I have always felt in why in arbitration in every dispute there should be a beginning with the mandatory mediation. There are med-arb clauses where you begin with the mediation. There are arbitrators who at the beginning try to devote some time to see if a reconciliation is possible and then only proceed ahead. But the only problem is that in true spirit, if a mediation has to be held, it will be difficult for an arbitrator who does an adjudicatory role to also be the mediator. So there I have a little reservation that the mediation process possibly should be before a different person. And if it fails, then the arbitration should go on. Because the arbitrator may try to settle it, but in the mediation process of having caucus sessions or where the party would come up really with disclosures about their interests, it may not be appropriate because ultimately the arbitrator is an adjudicator. But I am strongly a votary all over the world, countries which have been able to tackle volumes, including US or UK, it has only been through an active mediation process.
So we have a question from, sir, sorry.
So Asim, the point is you are trying to dovetail COVID-19 with the timelines given in the Act. And I think there have been some directions by the Supreme Court because of COVID-19 where they have, in a sense, frozen the timelines and said that, so therefore that should, in the immediate future, take care of those apprehensions that lawyers have that, we are not able to stick to the timelines given in the various provisions of the Act, and therefore, are we going to suffer the consequences? I don't think so. But that is the power, as I have often indicated, which is perhaps, if at all, to the Supreme Court under Article 142. But otherwise, the legislature could always look at it. I don't know. I mean, irrespective of whatever personal views that we have, Justice Call is how the legislature looks at it.
Yeah, I agree with you. It's not immediately germane from point of view of COVID. But my principle, which I propounded, was that in every dispute, commercial or otherwise, there should be a mediation. If you have to sort out this yearning volume of cases pending in court, more so because with the current scenario, the relevancy of COVID is that we don't know when will it end, how will it end, what will be the future of litigation, whether in court or mediation. How will that manner be carried on? Can we deal with the same volume that they are doing now with the social distancing being the norm? What manner courts will operate? And I don't think this is a short-term battle which we have at hand. So anything which helps in resolving a dispute outside the litigative process, I think should be welcome, more so in a scenario in which we are.
So there is a question relating to disclosure. Although it's a very simple concept, but I think there are many issues arising out of the mandatory disclosure under Schedule 6. So the question relates to what is the consequence of not giving a proper disclosure? Should a party wait for the final award, or should it go ahead and challenge the arbitrator under 12 and 13, or should it move to High Court under 14 for substitution of an arbitrator once they know that the disclosure is incorrect or has some concealment is there? So what steps should be taken by a party? Should it be going before the court in 14? Should it be going before the arbitrator in 12 or 13? Or should they wait for the award and then show it to the court while setting aside is taking place?
See, my own view would be the first thing is to point out to the arbitrator himself. So that the arbitrator cannot say that, in some sense, it is not something which has not been brought to his notice. Because ultimately, when you're throwing everything to the arbitrator, he's the person making a disclosure, and you say there is some other thing other than the disclosure which has come to your notice, which should create a situation for him to exclude himself, then I think it should first go before the arbitrator. It's a moot point if the arbitrator says no, should the courts intervene in between or only at 31st stage? Well, I would not like this stage to commit, except to say that there may be such a blatant misdisclosure that the purpose of going through an arbitration would be futile. And yet, if we permit the window too wide, then people on this issue itself will prevent the arbitration from them.
Thanks, sir.
Sir, another interesting question has come in, which says that suppose an arbitration clause provides for a unilateral appointment, does the party still go ahead with the invocation, or can they straight away approach a court in section 11?
See, you must, I would say you invoke the arbitration and then say, look, in view of a particular view, I'm approaching the court as it stands today. How it evolves tomorrow, I can't say, because this again become a fertile ground, I think, till the law settles down, as happened in other. Unfortunately, it's the threshold of section 11 which is going to generate all these issues. And my only concern is if this issue has to be looked in by, in a larger perspective, by a larger bench, when will the institution, giving the current situation and the backlog in the month, and by the time we get going, how will it be done? It's going to be an issue.
So there is a question from Mr. Gaurav Sareen, which is more topical. He is saying, in the present COVID scenario, will the need for digital database management, transcription and video conference hearing, would these factors affect the choice of appointment of arbitrators in an ad hoc arbitration while dealing section 11 applications? So in short, he's asking if the court would consider if the prospective arbitrator is tech savvy and has these facilities available or not.
Can I ask the question? Can we restrict a lawyer who may not be tech savvy? Can't. So therefore, people will have to learn to deal with it. There are some people more savvy, some people less savvy. People have learned to handle it. I think people will. There'll be no arbitrator, I'm sure, who can be said who is unwilling to learn if he is getting an arbitration. So ultimately, now the advantage of, say, institutional arbitration in this would be that the institution will provide for the wherewithals and the operations.
Shashank, I think we should restrict.
Shashank, I think just to come in, if Justice Cole will permit me, is if this analogy is taken further, then this would disable a lot of judges who preside over various courts, because it is only a medium. You know, your skills as a judge, as a lawyer, don't get whittled down just because you don't know how to operate technology. But having said so, as Justice Cole says, we need to progress to a stage where we are able to use it, if not, very proficiently, but at least be familiar with it, so that, But one of the things about transcription is something that we must try and get established in all institutional arbitrations. If not in ad hoc, it may not be sort of possible given the costs involved. That the evidence which is recorded by the arbitrator should be the evidence which is recorded as it is given. These machines are expensive, but in good institutions such as the Singapore International Arbitration Center or the Hong Kong Arbitration Center, they have their machines, because then the panel has a sense of what exactly the witness is saying, and not from cold print. Because demeanor of the witness, Justice Cole has done a lot of trial work, is very important to adjudication of any disputes. We are actually trying to implement that in courts also. Very soon you will find that in the lower courts, in criminal cases, evidence will be recorded, subject to some exceptions. Some categories may or may not. But evidence will be recorded so that the appellate court has that evidence available and the demeanor of the witness available. So yeah, technology in that sense.
The problem is not so much, one is the cost of the machine. And Singapore arbitration, I've seen it operated in the US courts for regular cases also, where the judge would say everything, whatever is said in court is recorded. And if something is off record, the judge will say this is off record. But the problem is finding the requisite manpower of expertise, because on operate these machines, it takes time to train them. And I don't know, we are today finding a paucity of stenographer assistance as it exists today itself. Forget these machines. So the machines have to come with requisite training of manpower to operate the machines. The future is, of course, there, and we should begin somewhere or the other, certainly. So even if the thing is not right, we should make a beginning and slowly introduce it, because that's important.
Asim, you were
Shashank,
saying
I think
something?
we're overshot. We should take just 2 more questions. So, sir,
Right, yeah.
last question from my end would be that Mr. Jeevan Panda has put this question: is whether do you think the railway electrification matter to some extent has diluted the effect of Weastelpine versus DMRC matter by allowing a limited panel of 4 arbitrators given by the authority and the same authority appointing the arbitrator on behalf of the other party?
Yeah, I said I have. What should I say? I can only say at this stage that I don't think the panel is so important, where the appointment process permits the concerned authority to appoint 2 arbitrators. Absolutely. And gives you a choice to pick up 1 arbitrator. So if you look at from the balance of the panel, why do we have an odd number of panel of arbitrators? Because you feel that even if there's 1 nominated by each party, they elect the 3rd arbitrator. So his perception will be maybe little more, some percentage more neutral, because he's not been appointed by the parties. If at all, that is the criteria. If that is the situation, then it is 2:1 in any case. So maybe it would have created a little problem insofar as government appointments of arbitrators are concerned. But dilution, yes, I feel it does. Therefore, I'm feeling the whole thing needs to be debated, crystallized, and cleared. Maybe at appropriate stage by a larger bench, so that there is complete clarity on this issue when there are different judgments emanating. This is a problem which Rajiv and I were discussing earlier, was that it arises from the Supreme Court being an institutions within institution, because it doesn't sit like the US Supreme Court with a single bench. And it is also sitting in benches of 2, benches of 3. Personally, I've always felt that even if admission matters are to be heard by benches of 2, that's fine. But possibly final hearing matters with appropriate strength, it should be heard by 3 judges to avoid this. Because I think in trying to dispose of more cases by creating more benches, the problem which is arising is more and more occurrences arise to 3 judges benches. So I don't know, this is a debate which will have to take place. Should all final hearing matters be held by 3 and 5 benches, and depending on the nature of the matter, and only admission matters be heard by 2 judges?
Justice Call, you would remember on this, on these, constituting larger benches in the 1940 Act, there was this big debate: should the arbitrators give reasons or not? And then we had a 7-bench, I think, 7 judges bench in Raipur development, where finally they settled the law that reasons have to be given, etc. So the panacea or the remedy is in larger bench, perhaps, deciding one way or the other.
In the sense, I feel at least this 2 and 3 benches issues, which is arising more frequently, should not arise. I'm not saying it will obviate the problem. I feel it will reduce the problem.
So, the last question that I'm taking is from Nikhil Rohtagi. He has a comment and a question. So he says, Justice Calls seem to be in favor of ad hoc arbitration, especially in smaller matters, technical matters, and family disputes. His question is, even institutional arbitration mostly would have a panel where technical and family experts are there. So would that not take care of these smaller matters, and therefore everything should go to an institution and nothing should be kept for ad hoc? Is what he's trying to ask. Your comments on.
Firstly, I'm not saying I'm in favor of ad hoc arbitration or against institutional arbitration. I'm only saying, practically speaking, when these matters come up in court, the tendency of both the lawyers and the judges to kill it there, if one may say so, rather than refer it to another authority. So far as family matters are concerned, I have a little different take. Often, you in family matters, sometimes you are able to explore in court the possibility of a family member who is respected by everybody, maybe even sometimes related, not directly, who may be able to resolve the issue, because something more than this, the rupee ana comes into it. Otherwise, these family disputes would not arise or would not be more complex than the commercial disputes in terms of resolution, because egos, hurts, all factors coming, and literally, as they say, sometimes both sides will want the half of the fork and half of the knife rather than take a fork and knife and separate. Some of these issues you need possibly a acceptable family person. Those kind of people will not be available in the institutional arbitration setup, because they would come in to resolve a family dispute. In the Indian context of joint family businesses, family partitions, which take the longest, family partition is one of the longest pending suits. I mean, if in the suit category you take any court, the two longest suits which take time are probate and succession, and their partition suits. That's a typical culture of the Indian system where these disputes arise, and I feel they need some other approach. Mediation is a very, very good approach, according to me. Even at the level of the Supreme Court, hearing these old appeals, I have tried and in a reasonable number of cases, I would say successfully have tried to work out where maybe between the litigation fatigue which has set in and the nature of family matters, because the family relationships are broken at times. So you can, I can give immediately an example to clarify. There was a battle between the brothers and sisters, and ultimately I said, why can't this be sorted out? And they've been fighting for decades, and it was felt that the children of the sister are not letting it settle. So the perception, and you're able to, with the assistance of the lawyer and some third family member, arrange for, without discussing, the sister to go for a lunch to the brother's house, and this will be acceptable if the third sister who's not claiming anything will also come. It began with the lunch, and by the time they came back, they were able to sort it out. See, now this kind of a thing will only happen in a mediation or will happen on a impetus of a court, because the institutional system cannot provide for it. So it will depend case to case. I would certainly say family issues, I don't know. I'm not so confident that the institutional arbitration system can sort it. It needs a different handling. It sometimes needs a handling of somebody within the presence of the family.
Yeah. Before I conclude, Justice Shakdar, you wanted to say something, sir?
Yeah, just one bit. I mean, Justice Kaul is right, because family disputes is a different genre altogether, especially in the Indian context. But we've tried to address this problem, if you recollect, in the Delhi Arbitration Center, by having arbitrators who act pro bono. I mean, for smaller cases where they will not charge you any money, and some of the lawyers have done it. And one of the indices that we take into account when lawyers apply for designation, Justice Kaul, is how many pro bono cases have they done, either as lawyers or even as arbitrators or mediators. So I mean, that's one way to go forward.
No, I'm only saying sometimes the stakes can be very high. You're talking about small. Family matters, often stakes can be very high, and so that it probably one particular generic kind of smaller disputes you are referring to, but some of them need far more caucus sitting. People, maybe mediators and arbitrators, experts in the field of family matters. Or I say sometimes, my own belief is that sometimes elder of the family is able to.
No, which is why I said Justice Kaul. Which is why I said Justice Kaul, they fall in a different category altogether. I mean, family disputes. So you are right. You need an elder in your family.
I recollect as a lawyer persuading a friend and a litigant both to agree to an arbitration by a grand uncle who also happened to be a retired judge. And once he had made the award, he asked me, parties kya keh rahe hain? So I said, sir, both are a little unhappy, so I think the award must be fair. So, and nobody challenged it, because they knew that grand uncle had a stature where right or wrong, the nephews would not go and challenge it. You see, I'm told in Calcutta and amongst Marwadi families in Gujarat, there are a lot of places where the dispute doesn't even go to court. It gets resolved through within the community or family. This thing. That's also an education process in some way, not through an institutional setup.
So on the contrary, I have, in my experience, realized sometimes court looking at cross appeal says both the parties seem to have problem with the award, so it should be set aside. So that's the other extreme.
That's sometimes a threat used to maybe make the parties see reason.
If both parties have a problem with the award, then there is no problem with the integrity of the adjudicator, certainly.
So before I conclude, there is a question that has come for Justice Shakdar, but I would not put this as a question. I would rather just communicate this in his capacity as the judge in charge of original site. In the recent Delhi High Court notification, sir, section 11 has been omitted. 9 and 34 seems to have been permitted in the scope of urgent matters. You may want to have a relook at it. That's what the some of the viewers have requested. So
Okay, I'll carry the message. You can tell your audience I'll carry the message to the relevant judge who takes, or the relevant judges who take decision in the matter. I am at the threshold of the AC at the moment.
You are the judge in charge, Raju Shakdar.
Thank you.
Thank you, sir. Thank you very much for joining us on a Wednesday evening. Thank you all the audience for signing in. I'm grateful to all the support that we have received from all the supporters, including Khaitan and company, for their tech support, Bar and Bench as a media partner, Manav Rachna University, Society of Construction Law, Young Leaders Group, Indian Arbitration Forum, and Arbitration India Group. Thank you all. We have also sent out a compilation of judgments to various groups where this webinar was advertised. In case anybody has not received that compilation, could reach out to either of the moderators. Would be happy to share all the judgments which were covered in the discussion today are already there. Just call, you were saying something, sir?
No, just thank you.
Thank you.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you, Justice Call. Thank you, Shashank, and thank you, Asim.
Thank you, sir.
Yeah, God bless.